Hi, everybody, and welcome to today's webinar. The topic is Certificates of Pending Litigation, Pitfalls, Insights, and Recent Developments. So let's get started. Can everybody hear me okay and see the slides on the screen? If somebody can type in the chat that they can hear me and see everything okay. Okay, perfect. Thank you very much for confirming. So let's get started. So as I mentioned, the topic today is Certificates of Pending Litigation. And first, a little bit about me and our law firm. So Counsel Litigation, which is hosting this webinar, is a boutique litigation firm. We have offices in Toronto and Vaughan, and we serve Toronto, the entire GTA, and rest of Ontario. We have 2 lawyers and support staff. We practice in the areas of real estate litigation, commercial litigation, and estate litigation. Our cases have been featured in respective publications such as Thomson Reuters, the Toronto Star, and Mondac. My name is Nick Tenev. I'll be the presenter today, and I'm also the principal of Counsel Litigation. A little bit about me. I started my career on Bay Street. I have a background in engineering. My undergrad is from the University of Toronto. I graduated law school from Western Law, and I'm a 2016 year of call. And since 2019, I've been operating Counsel Litigation with a focus on commercial litigation and real estate litigation. So the agenda for today is as follows. First is the introduction, which I just did. We'll then go over the key concepts regarding certificates of pending litigation, what they are, how they work, examples, and so on. Then we'll look at some recent and seminal cases. And at the end, we'll have some final words to finish things off and some questions and answers. Overall, the webinar should be around 45 minutes. And the focus of this webinar is on recent developments. We will be looking at Ontario cases. And although we'll be looking at certain cases, we'll be trying to extract the broader principles so you can apply those to future transactions as real estate solicitors. And the target audience is real estate solicitors, but everybody is welcome to attend. And the goal of the webinar is to help solicitors stay current in the law and to better handle difficult transactions and prevent transactions from failing or encountering difficulties. And there are a few non-lawyers attending. So a little disclaimer, this webinar is not legal advice. It's not to be relied on or acted on. It does not create a solicitor-client relationship. And Counsel Litigation and myself, the presenter, are not liable for the information in this webinar or how it's used. Please seek legal advice for your legal matters right away. And if you have any questions, please put them in the Q&A box, and please use the chat box for any comments or technical issues. It just helps to separate the questions from the general comments. Okay, so on to the main presentation on certificates of pending litigation. So this is the agenda for the substantive part of the presentation. So we'll look at what are CPLs, certificates of pending litigation, why obtain them in the first place, and we'll look at some examples. We'll also look at the governing statutes. We'll look at the test for how to grant or discharge a certificate of pending litigation. We'll look at recent cases. We'll look at how to obtain them more specifically in terms of using whether to use a ex parte motion. I'll explain what that means. It means obtaining without notice to the owner of the property, but I'll talk about it in more detail. Don't worry if you don't know what it means at this point. We'll also look at the risks of obtaining CPLs. They sound great, but there are downsides which you need to be aware of. We'll look at also alternatives. What are some other options if a client does not want to obtain a CPL? And we'll look at recent cases at the end. Okay, what is a CPL? So I realize many of you probably know what it stands for or what it is, but let's start with the basics. So a CPL is a Certificate of Pending Litigation, and it's registered on the title of the property. And it provides notice the property is subject to a court proceeding. So anybody who searches title can see there is this registration and that there's some litigation involving this property. And the CPL technically does not prevent the sale or the dealing with the property, but in effect it does, because anybody looking at this property, searching this property, will see that there's litigation. And if they deal with it, if they take ownership of it, they will be taking on that litigation. Their ownership or mortgage or whatever will be subject to that litigation. So in reality, nobody really wants to do that. So in effect, it does freeze the property. It does prevent the dealing or selling, mortgaging of the property, because most entities, most people would not want to deal with a property that's involved in litigation, because you would be assuming the associated risk. And this is what a judge said from a recent 2026 Court of Appeal case. The purpose of a CPL is to give notice that an interest in land is in question in litigation. It serves to prevent the claimed interest from being defeated by a transfer or other dealing with the land in favor of a person who otherwise could assert they acquired the land without notice of that claimed interest. So just an example of how a judge puts it, so you can see more clearly what a CPL is and how it works. Okay, so what are some examples of situations in which you might want to use a CPL? So there are several situations. One of them is if you have a real estate transaction and for some reason it is not completed. The transaction fails and there's a dispute. And let's say the buyer wants to force the seller to complete the transaction. In that case, the buyer might want to choose to obtain a CPL in order to prevent the seller from dealing with the property. So that's one example. Another one is fraudulent conveyances, number 2 on the list here. So if an owner tries to transfer properties, or actually has already transferred properties to other parties in order to defeat creditors, the creditors can seek a CPL on those properties to prevent further dealings of those properties. So it's kind of to prevent the properties from being further dealt with, to protect the creditor's interests in case they were initially transferred fraudulently. Number 3, trust law claims. So sometimes a person or an entity has an interest in a property that's not registered. So for example, maybe that person or entity has a beneficial ownership interest in the property. For example, maybe they've made improvements to the property. Maybe they've contributed money towards the purchase of the property. There could be many situations, but essentially it's situations where somebody has a trust interest in the property. They're not registered on title, but arguably they have an interest, an ownership interest in that property. Number 5, family law claims. So we see CPLs in family law situations. I don't practice family law specifically, but if you look at the cases, you'll see a lot of family law cases where you have spouses and they have one property or maybe multiple properties, and maybe somebody has renovated the property, put money into repairing the roof or something, but they're not on title, or maybe they've contributed some money but they're not on title, and then they make ownership claims and they seek a CPL to protect their interest in that property so the property doesn't get sold or mortgaged. Number 6, fraud. So if funds are obtained fraudulently, so somebody embezzles some money, takes some money from, I don't know, a business or something, and then uses that money to buy a house or to renovate a property, then the innocent party can seek a CPL on that property to prevent further dealings with that property. Okay, so those were some examples. Now, what statutes give lawyers the right, or clients the right, to register a CPL? Well, there's Rule 42 of the Rules of Civil Procedure, which grants the courts the right to issue or discharge CPLs. And then we also have Section 103 of the Courts of Justice Act, which has some further provisions there regarding liability for unreasonably registering CPLs. I'm not going to go into these in detail, but in case you were wondering, where does the authority to register CPLs come from? It's these statutes here. And CPLs are a very powerful remedy because they're granted before trial. So most times you have to go to trial, you have to go in front of a judge, argue your case, and then the judge decides what to give you. But CPLs, they're given before trial. So it's a very powerful remedy because you get to get some sort of remedy without fully arguing a case. And it's a very powerful remedy, as we saw. It can prevent the owner from dealing with the property. And what is the test for granting a CPL? So how do we get these CPLs? Well, essentially, it's a three-part test. So number one, the party must have a claim to an interest in the land. So it has to be land related. Number two, and we'll see more about that later, by the way, because it might not be very intuitive what that means, but we'll see that later. But number one is there must be an interest, a claim to an interest in the land. Number two, there must be a triable issue. And number three, the courts look at these discretionary factors. They look at the situation, the totality of the situation, and they examine many factors of whether they should grant the CPL. I'll go over all these in detail next. And sometimes these discretionary factors, number three on the list here, are called the Duna factors because it's from this seminal Duna case. But the factors actually go beyond the Duna case. So although people call them the Duna factors, it's the seminal case, but since then they've been expanded and it's not an exhaustive list of factors. Okay, so let's look at number one, the first step. The claim must relate to an interest in the land. So it's important to note that the CPL is not designed to be a security for a court proceeding that is not related to land. So, for example, if somebody owes you money for something, you loan them money to buy a car, and they're not paying you, you can't then seek a CPL on their house to secure your judgment. Let's say you win the judgment. Let's say a judge decides, yes, you gave this person $20,000 to buy a car. They haven't paid you back when they were supposed to. You now have a judgment. You can't then go seek a CPL on their house to protect your judgment for the money you gave for their car. It has to be, you have to have a claim to an interest in land. Number two, as I mentioned, is whether there is a triable issue. Now, what does that mean, a triable issue? So what that means is that when somebody applies for a CPL, you have to bring what's called a motion. So you have to argue your case to a judge for a CPL. And the judge does not decide, whether whether your claim is successful or not. Basically, they're just looking to see if you have a triable issue, which means you potentially have a valid claim. So if you're saying, hey, I made renovations to this property, I put in $20,000 in this house to renovate the roof. Therefore, I have an interest in this property. I need a CPL. Judge, please grant me the CPL. So the judge is not deciding whether you, in fact, provided $20,000 in renovations to this property and whether everything you're saying is true and whether the other person owes you money. The judge just decides whether you have a triable issue. And what that means is you potentially have a claim. So there's enough evidence there that a judge thinks this issue should go to trial to another judge to decide. So it's a relatively low bar. Essentially, you have to show that you have a potential claim. And this is what the court said in this Gentles versus Lynch case. The threshold test is met where there is sufficient evidence before the court to establish a claim to an interest in the land, which the moving party could succeed. The moving party need not show a likelihood of success on the merits. There may be a triable issue even where the moving party's evidence appears weak. So it's a very useful recent case to show that even weak evidence could be enough for the granting of CPL. And this judge here stresses that, the CPL, the judge deciding whether to grant the CPL is not deciding the entire case or whether the case would succeed. They just want to see there's enough evidence that there could be success. And that's how, that's the threshold for granting the CPL, even if the evidence is weak. And the judge goes on to say, in determining if there is a triable issue, the evidentiary bar is low. The court is not to assess credibility or decide disputed issues of fact and credibility. Again, just further explains how the bar is pretty low in granting these CPLs. And there have been cases where the CPL has been rejected due to insufficient supporting evidence. So even though the bar is low, you're not automatically granted a CPL. You still have to put an effort to convince the judge that there is a tribal issue that you potentially would succeed with your claim. So, for example, in this 2023 case, some things the judge said in that case were that the evidence of the plaintiff was weak. Their claim was supported by uncorroborated evidence. There was insufficient evidence of a tribal issue related to an interest in land. So the CPL was rejected. So the judge in that case decided the evidence simply did not meet the threshold. Even though the threshold, the bar is very low, in that case, it was not met. And in another case, I just thought it was interesting, 2013 case, the judge said that the plaintiff has a viable claim in theory, but difficult of success based on the evidence. It meets the threshold test of a CPL. So in that case, the judge was critical, he criticized or she criticized whether the claim would succeed, but it was viable, there was enough there, and the CPL was allowed. In another case here from 1999, the judge said a self-serving affidavit is not sufficient in itself to create a tribal issue in the absence of detailed facts and supporting evidence. So what that means is that the plaintiff can't just go and provide as the evidence only a self-serving affidavit. What that means, an affidavit is a sworn statement. So they're swearing what happened. And they can't just swear things that are in their favor and expect that to be enough. There has to be more to it. You have to have detailed facts and supporting evidence. So I'm showing these cases because, it's not a black and white concept of what the bar is, the threshold is, but we can see there is the threshold, and, the claimant, the plaintiff has to put in effort and has to provide some evidence to convince the judge that there's potentially a claim. And so the takeaway here for solicitors is that the bar is relatively low for a tribal issue, the tribal issue part of the test. However, the claimant must provide evidence, not just the self-serving affidavit. So, if you have a client who is saying, well, I'll tell the judge, what happened and that'll be enough, that might not be enough. Your client might have to provide some supporting documents, maybe some bank statements or receipts, maybe some witnesses, just maybe something to convince the judge that, their side of the story is correct and that they need to be heard, that there's a tribal issue here. And the defendant, the other side, they can actually defend against the CPL if they provide their own evidence. So if the defendant has better evidence, the judge might actually decide that the plaintiff's evidence is not strong enough and the CPL should not be granted. And we'll see that in a minute. So the third step of the test is these discretionary factors. And basically, it's a non-exhaustive, very discretionary list of factors that initially come from this Duna case, Numbered Company versus Duna. And the courts have been using these factors since this case and expanded on them. And essentially, the courts look at the big picture, the whole picture, and all the facts and all the factors in deciding whether to grant the CPL. And as I mentioned, it's a non-exhaustive list of factors. The courts take a holistic approach, and no one single factor is determinative. So there's no silver bullet or anything like that. It's a holistic approach, weighing all the different aspects of the situation. And this case here from 2025, there's a quote here I found very useful that the court said, the usual test for a CPL involves consideration of whether there is a tribal issue related to an interest in land and consideration of the equities and the balance of convenience. So you can see the court kind of talks about these equitable factors and balancing whether to grant the CPL or not. As I mentioned, Duna is a seminal case from 1987. And more recently, in 2010, is another important case, this Perusa versus Spatoni case. So these are very important cases in terms of CPL and these discretionary factors. In the Perusa case, the court said, for example, there is more risk of serious harm if the CPL is not granted. So again, goes back towards what I said earlier, that the court tries to weigh whether to grant the CPL or not. Is there more harm done if the CPL is granted or not? In this other case here from 1977, the judge said the following: the judge must exercise his or her discretion in equity and look at all the relative matters between the parties. Again, just speaks to the holistic approach that I was talking about, looking at all the factors, all the matters between the parties. So what are some of these DUNA factors? Well, the courts have said, for example, that they would grant a CPL if damages and other remedies are not effective. So if money alone, a money award is not enough, they might grant a CPL because maybe it's better to grant an interest in the property or for the plaintiff to be able to pursue the property. So for example, in this 2026 case, the court said, courts will not issue a CPL where damages are sufficient. A certificate is intended to protect an interest in land only where other remedies would be ineffective. So here's a list of some of these factors from the DUNA case: whether the plaintiff is a shell corporation, whether the land is unique, whether, the intent of the parties in acquiring the lands, whether there's an alternative claim for damages, the ease or difficulty of calculating damages, whether damages would be a satisfactory remedy, the presence or absence of another willing purchaser, harm done to the parties if the certificate is allowed. So you can see there are many factors which consider many aspects, and it also takes into consideration the interests of the person seeking the CPL, the interests of the owner who might be harmed by the CPL, and even the interest of a potential third party that could be a purchaser that could suffer harm if the CPL is granted. And we can see here that the courts really look at whether there is an interest in the land and whether the land needs to be essential to the plaintiff's claim. So if the land is unique, for example, if a purchase transaction fails, do the buyers really need this property that they're purchasing? Do they really need a CPL to tie up this property that they want to purchase? If they can purchase the exact same property, a few doors down, why should this property be tied up by a CPL, right? So there's factors like that. And also if monetary damages are enough, why provide a CPL? Maybe the buyers are okay with just getting money as damages. Maybe, they want $100,000. Maybe they don't want the property. So in that case, maybe a CPL will not be granted. So let's look at a case which analyzed these factors. So the case is from 2026, this Binio versus Kotarak case. And the two people, the plaintiff and defendant, were common law spouses. They cohabited. And the plaintiff alleges he contributed $97,000 for the purchase of the property and also did renovations. So he's not on title, but he's saying, hey, I gave money for the purchase of this house and I also did renovations. So I have an interest in this house. Judge, please grant me a CPL. And the defendant alleges the plaintiff did not contribute to the purchase of renovations. He only occasionally cut grass and shoveled snow. And also, the harm in granting a CPL here is that the defendant, which is the registered owner of the property, needed to sell or refinance to pay for her carrying costs, personal expenses, and son's university. So a CPL would cause her harm here because she wouldn't be able to refinance to pay for certain things she needed to pay for. And the court acknowledged this by saying a certificate would impair her ability to refinance or sell. In contrast, the evidence indicates that there is substantial equity in the property, estimated at approximately $600,000, which would be available to satisfy a monetary award should the plaintiff succeed. The court also analyzed that the plaintiff provided no documentary evidence of his alleged financial contributions, provide no description of the alleged improvements, and also analyzed that the defendant reported rental income from the plaintiff, which undermined his assertion that the parties jointly owned or intended to jointly own the property. It made the plaintiff seem more like a tenant, a renter, not really an owner, because he was paying this rent. And the courts again stressed that they're not looking to decide the entire case, whether the plaintiff is successful in their claim here and is owed money. They're just looking to see whether the threshold is met for a CPL. So the court said, I emphasize that I'm not determining the merits of the action. However, in weighing the equities, it is relevant that the defendant has provided considerably more evidentiary support for her account than the plaintiff has for his. A relevant discretionary factor is the strength of the plaintiff's case. So we can see in this case that the judge weighed the evidence of the plaintiff and defendant, and although the bar is quite low for granting a CPL, the judge decided that that low bar was not met in this case. So the CPL was denied. So what is the takeaway? The bar for CPLs is low, but sometimes it is not met. And the evidence of the two parties will be weighed. So the judge will look at the strength of each person's evidence and will take a holistic approach. In this case, we saw, going back here in the slides, that the judge also considered that the defendant, the owner, the registered owner, would not be able to refinance to pay for her carrying costs, son's tuition, things like that. So a holistic approach is taken. So the takeaway again is that there's a low bar, but it must be met. And there's these discretionary factors which the courts take into account, whether a CPL will be granted or not. And there's many factors and there's lots of discretion. So basically the broader takeaway here is that whether a CPL will be granted or not is not an easy answer. So you might have clients who, for example, think they have an interest in the property or are alleging to have an interest. They contributed money or they did some work and they're going, hey, I have an interest. Can we register a CPL? The answer is, as we like to say as lawyers, maybe. And it's good to explain to clients that, it's not very easy to predict whether judges will grant a CPL. The bar is quite low, but your client does have to provide evidence and does have to be able to establish their case to, it's a pretty low threshold, but they do have to convince the judge that they potentially might have a claim to this property. And at the same time, the defendant has a chance to also present their own evidence to convince the judge that the plaintiff does not have an interest. And there's many factors that the court takes into account. For example, is the property unique? Why do you have to tie up this property? There's so many factors. It's hard to know what a judge will decide in granting the CPL. Sometimes they might decide that, hey, you're owed money and a monetary award is enough. You don't need to tie up this property. Or maybe it's a failed real estate transaction and the buyer is upset that the seller failed to complete the transaction. But the property might not be unique. And a judge might say, well, I'm not granting a CPL because this property is not unique. So there's many factors. It's hard to predict. That's kind of the broader takeaway, is it's hard to predict if a judge will grant the CPL because of these discretionary factors. There's no kind of one determinative factor. It's many factors and there's lots of discretion. And how do you discharge a CPL? Maybe you have a client who has a CPL on title. Maybe you're doing a closing and a CPL pops up and, they freak out, how do we get rid of the CPL? Well, it's the same test as granting a CPL, the three-part test that I mentioned. Is there an interest in land? Is there a tribal issue? And then you also look at these discretionary factors. So your client would have to bring a motion to discharge the CPL. And again, they would have to establish that there's no interest in land or there's no tribal issue, or even if there is an interest in land and a tribal issue, that based on these discretionary factors and taking this holistic approach, the CPL should be discharged. So it's the same test for discharging a CPL as it is for putting it on. And can you bring a motion for CPL without notice to the owner? Yes, you can. This is what's called an ex parte motion. And the reason that I bring this up is because sometimes if you bring a motion for a CPL with notice to the other side, with notice to the owner, then they might sell the property or mortgage it, or deal with it in some way that's adverse to your client's interest. So if they have notice, they might do something to sell the property and run off with the money. So the ex parte motion just means that the claimant, the plaintiff, is able to seek the certificate of pending litigation without notifying the other side. So they just present their case to a judge and have to convince the judge without the other side being able to show up and defend themselves and present their own evidence and their own arguments. So this might sound great. You get it quickly. You don't have to argue against anybody. So why not do it every time? Why not do each CPL motion without notice? So as I mentioned, the benefits are it's quicker. You don't have to argue against the other side. Therefore, the CPL is probably more easily granted and granted much faster, of course. And you also can probably get the CPL before the property owner can sell the property or deal with it and dissipate the funds from the property. But there's a downside, right? Why not do it every time then? Do it without notice. Well, the downside is that there's a higher risk for the claimant, for the person seeking the CPL. If the owner is not present to present their arguments, evidence, and relevant facts, then there's a higher chance that the claimant can be incorrect in the way they're presenting the facts or their own arguments. It's very one-sided, of course. They do have a duty to present the facts in a kind of a reasonable or fair manner. They cannot omit important facts. But obviously, there's a high risk they might do that. They might be very one-sided and leave out important stuff. And then later, it can be determined that the CPL was granted improperly when the owner actually finds out that there was a CPL and they argue against it. They bring their own motion to discharge it. So essentially, it's riskier because the other side is not there to argue and present their own facts. The claimant who obtained the CPL can be found liable for presenting a one-sided story and obtaining a CPL improperly. So this is the takeaway for solicitors there is that, if your client wants to seek a CPL, but is afraid that the owner might, have notice of it and then sell the property right away or mortgage it or deal with the property in some way once they have notice, you can advise your clients that there is this option of the ex parte motion, but you have to be careful and present the facts kind of in a fair way. It can't be very one-sided. Because the owner is not there to defend themselves. And the claimant can be found liable for obtaining a CPL improperly if they don't present the facts clearly and kind of in a fair manner. Okay, so we looked at what a tribal issue is. We looked at the discretionary factors, those DUNA factors. But how about the first step, the interest in land? It sounds pretty simple, right? Interest in land, how difficult could it be? But it's not very simple. It's not always intuitive what it means for somebody to have an interest in land. So an example where somebody might have an interest in land that is not intuitive is if, for example, somebody's holding money in trust for somebody else and then takes that money and puts it into a property for improvements or to purchase a property. So that money, those trust funds were supposed to be used for a certain purpose, but instead they were used to purchase a property or to renovate it. So this is a little maybe not intuitive because the innocent party has actually no direct interest in the property, right? They're not claiming to be an owner or anything like that. They just had some money that was sitting with somebody, and that person then took off with the money and put it into a property. So that's a situation where maybe it's not super intuitive that the innocent party has an interest in land. And we see this in this case here from 2017, where the court said, similarly, a claim based on the doctrine of constructive trust in respect of property, including the right to trace funds, may give rise to an interest in land. So if you can trace those trust funds into the property, that can give an interest in land. Another example is fraud, fraudulent money. Let's say an employee or a director steals money from a company or takes money improperly, embezzles money from a company, writes a check to themselves, and then uses that money to buy a property or to renovate a property. So that can potentially qualify, for a CPL because if the money can be traced into that property, that can be an interest in the land. Also, another interest in land, a situation where maybe it's not very intuitive that there is an interest in land, is fraudulent conveyances. So these are situations where an owner has creditors, people he owes money. Maybe it's a judgment, maybe it's a loan they defaulted on, but people are after this person for money. And to hide their assets or to protect their assets, they transfer those assets, let's say to family and friends, to people that will hold those assets for them in order to defeat the creditors. So that's a situation that would likely be a fraudulent conveyance. And those situations allow a CPL. But again, it's a situation where it's not very intuitive that the innocent party has an interest in the land because, for example, with the car example that I gave, you gave somebody, I don't know, you have a judgment against somebody, against a person for, let's say, $200,000. You win in court, you get your judgment for $200,000, and now you want to seek payment from the person you won against, and they go and transfer their house to somebody, to their mom or their child or something, so you cannot go after their house. So that would be a fraudulent conveyance, and you can likely register CPL, but you never really had an interest in their house. Money was never traced to the house, right? You never claimed to be an owner, yet you can register CPL. So it's one of those situations where the first step of the test, it doesn't really make too much sense in these situations, but the courts still grant a CPL in those situations. And in this case from 2021, the court said a CPL may issue in an action to set aside a fraudulent conveyance, even if the plaintiff has no interest in the land and is not yet a judgment creditor. The standard to meet for obtaining a CPL in an action to set aside a fraudulent conveyance is a prima facie case of fraud. So we can see the quote in this case where the judge said that the plaintiff who has no interest in land can still obtain a CPL, which kind of, sort of goes against what the statute said or other cases that the plaintiff does have to have an interest in land. In cases of fraudulent conveyance, the plaintiff doesn't really directly have an interest in land, yet a CPL can still be granted. So that's the takeaway for solicitors, is that if your client, for example, thinks there's been a fraudulent conveyance, somebody owes them money and that person is transferring properties to defeat the creditor, a CPL can still be granted, even if your client, didn't have kind of a direct interest in the property. They didn't claim to be an owner. They could not trace their funds. They did not give funds for the purchase of the property. They can still probably get a CPL. And are there any risks to getting a CPL? So we have this case here from 2024 where the claimant obtained a CPL and tied up the property, of course. So the facts are as follows. The defendant and plaintiff were in a common law relationship for 15 years. They bought several properties together, some of them jointly or some of them in one person's name. They would rent, renovate, and flip them. So there was a dispute about who owns a certain property or the money, the proceeds from that property. And so the plaintiff brought this ex parte motion, again, without notice. And what he did is that he actually submitted fake invoices to show that he did work in the amount of $140,000 on this one property. And he was able to obtain a CPL based on this fabricated evidence. And later, when the the issue was tried, it was discovered that this CPL was improper and that the plaintiff had no reasonable claim to this property. And the plaintiff was then liable for damages in the amount of $241,000. And this is because the plaintiff tied up the property with this CPL. It was tied up improperly, and the owner wanted to sell the property for 1.64 million, but ended up selling it for 1.399 million because the market went down during that time, during the time during which the property was tied up because of the CPL. So this shows you the liability, the risk in putting on a CPL. It's not, there is a risk. Clients should not rush into obtaining CPLs. Clients should be advised of the risks because the threshold, remember, is very low. These CPLs can be relatively easy to obtain, but later can be decided that when the full evidence is heard, that it was improperly granted. And also later, the defendant, initially it might be granted ex parte without notice. So then it's especially easily granted. And then later, when the defendant defends or presents their own evidence, or when the broader litigation is decided, it could be decided that the CPL was improper. So that's the takeaway. Clients have to be very careful in obtaining CPLs because they're easy to get, but later can be determined that the CPL was improper and the client can be liable for damages. And as I mentioned, this is especially important in ex parte CPL motions because those can be especially easy to obtain. Okay, are there any alternatives? We're just running a bit low on time here, but I'll wrap it up. So are there any alternatives? Yes, there's Mariva injunctions. I'm not going to explain those in detail, but Mariva injunctions are there to preserve the assets, of somebody if you're going after their assets. So if your client has a judgment against somebody or is afraid that somebody is going to dissipate their assets and your client will not be able to go after that person with their assets, your client can seek a Mariva injunction that freezes the person's assets to satisfy a judgment if there's concern that the assets will be dissipated to defeat the creditor. This is just a quote from this 2026 case, which we examined earlier, explaining how a CPL is not a substitute for a Mariva injunction. So a CPL is not there to prevent the dissipating of assets. And the other alternative is cautions. So those are registered for 60 days. I'm not going to go into them in detail, but just know that there is the option of doing a caution, which is obtained much more easily. You can just go and register it. And of course, there is liability there as well, because if your caution is deemed to be improper, then your client can be liable for tying up the property for 60 days. And many times the caution is kind of a quick measure to tie up the property while the client prepares for a CPL motion. So it gives the client 60 days, to prepare to file a CPL motion. Okay, let's look at a recent case. I know we're out of time, but just one recent case here. So this case involves a dispute involving several residential properties. We have this plaintiff and this defendant. They were, working together to renovate properties, buy properties, and they had this agreement between them that the properties could not be sold until the private loan was fully repaid. So one party gave a loan to another party to renovate a property, and the agreement said, hey, you cannot sell that property until you fully repay me. The loan was not to be registered on title. That's what the agreement said. Hey, this loan cannot be registered on title. So following a dispute over repayment, the plaintiff commenced legal proceedings and sought to register CPL over the properties. So again, the agreement said the properties cannot be sold until the loan is fully repaid, and the loan was not to be registered on title. But, there was a dispute about payment, and the plaintiff commenced the CPL motion. So did the judge allow a CPL case in this situation? Let me put a poll here. Just bear with me while I do the poll. So choice A is yes, and choice B is no. So it should be up here in a second. Okay, I'll give a few seconds for you to vote. So I'll pull up the facts again. So one party, the plaintiff, gave a loan to the defendant to renovate this property that the defendant owns. And the agreement said that property cannot be sold until the loan is fully repaid. The loan was not to be registered on title. The defendant doesn't pay. The plaintiff wants to get a CPL, where they allow the CPL. Okay. Okay, I'll give 5 more seconds here for any last submissions. Okay, so 27 people answered, so 19 people said yes, so 70%, and then 8 people said no, 30%. So 70% of you said yes, the judge allowed the CPL. So the answer is actually no, the judge did not allow the CPL, and this is why I am showing this case, because it's not always intuitive. You would think, hey, this money was given to renovate this property, therefore the plaintiff has an interest in the land. But the judge did not see it that way. The judge saw that the loan was actually in personam. So in personam means that the obligations with the person, it was a personal loan. It went to the defendant, not to the property. So it's enforceable against the person, the defendant, not the property. So in this case, breaching agreement gives a claim for damages, but it does not give a proprietary remedy. So it does not give a right to go after the house. So the way I would think of this is as, the money was given to the defendant for a certain purpose, but that's kind of where the connection ends. What that defendant then does and where the money goes, the plaintiff cannot go after those things. They can only go after the person they loaned the money to. It's like a credit card. Think of it like, you have a credit card. The credit card company gives you money. You buy whatever. You buy a TV. You buy a car, whatever, with the credit card money. The credit card company would be going after you. It wouldn't be going after those assets right away. It wouldn't seek like there's no CPL for those things, but it would not seek some kind of specific remedy against those assets. So same here. The plaintiff could only seek a remedy against the defendant personally, not the underlying asset, because it was seen as a personal loan. And the judge said that the CPL could not be used as security in these contractual disputes, and that a damages award would be more appropriate. And also the judge looked at that term, which said the agreement was not to be registered on title, and further helped the judge decide that this was a personal loan. This was not money that the plaintiff directly injected into the property. It was money they gave to the defendant, who then used it for renovating. So this was a contractual breach, no direct claim to the land. And the judge also analyzed the DUNA factors. They said there's no interest in land, but let's take a look at the DUNA factors. And based on those factors, the judge also said that they don't think a CPL would be appropriate. They thought monetary damages would be enough. There's no need to tie up the property because the property was not fully renovated yet or fully constructed. So it would be kind of overkill. It would be excessive to put a CPL on it. So what is the takeaway here? CPL is not meant to be a security for unpaid debt. The claimant, the plaintiff, must have a direct interest in the land. So if it's a loan to the person, then probably there's no interest in the land. But overall, we can see it's difficult to predict when the courts would grant these CPLs, and this is due to the interest in land analysis, the interest in land step of the test, and the DUNA factors. It makes it difficult to know if the judges would award these CPLs. Also, obviously, the triable issue step of the test. Sometimes that is a difficult step as well. So overall, it's difficult to predict. There's some other cases here. We'll post the slides. We'll post the presentation, the webinar on YouTube. So there's some other cases if you wanted to read on some other recent cases. I've just included them here, but I'm not going to go through them because we're short on time. And that's the end of the webinar. So thank you very much for attending. If you have any questions for us, you can reach out to our email here, info@counsellitigation.com, or call us at this number. And we also have a referral program. So if you do have a litigation matter, we pay a 15% referral fee. And we have a great team here. We're experienced, practical, efficient, and solutions-oriented. And you can join our newsletter. We have a monthly newsletter with recent cases. I think we covered this case in one of our newsletters. So it'll help you stay up to date with the law. You can email us at info@counsellitigation if you're not subscribed, and we're happy to add you to the list. We also have a Facebook group if you want to join it. There's other real estate lawyers there. It's a group for real estate solicitors. And you can ask questions. I'll post it here in the chat. The link I've posted in the chat if you want to join. Be great to have you. And also at the end of this webinar, you'll get a short survey. Please fill it out, and 2 of you will be selected randomly for a $20 Starbucks gift card. And please complete the survey in the next 24 hours. Okay, so that's it for today. The next webinar, we don't have the date determined yet. So if you subscribe to our monthly newsletter, it will have news on the next webinar there. But that's it for today. And any questions? Now it's the Q&A part of the presentation. So if you have questions, please put them in the Q&A box, which I will pull up now. Okay, so we have 2 questions. Can a CPL be pursued absent the commencement of a statement of claim or notice of action? So great question. So no, you do need a statement of claim. I didn't want to cover that because it kind of becomes a little technical, and it's more litigation type stuff, information. But yeah, it's a great question. You first have to bring a statement of claim, and then you do a motion for the CPL. The next question is, how would I identify a certificate of pending litigation on a property parcel register, or would it not be indicated up on the parcel? So it would be registered on the parcel. I forget what the actual line says, but I think it'll be very obvious. I think I got to pull up one I've seen recently, but you'll know. I think it might even say Certificate of Pending Litigation. I think it's a notice, or I can't recall, to be honest. I've definitely seen many of them, but I can't recall what the actual wording says on title. What remedies? Next question. What remedies does a person have after CPL expires after 60 days? So the CPL does not expire after 60 days. It's the caution that expires after 60 days. So your client can register a caution without the court's assistance. So for a caution, you don't need permission from the court. You can go just register a caution. Again, your client could be liable, though. Just because you can go and register, it doesn't mean there's no consequences. If you put on a caution and it's deemed to be improper, then your client can be liable for tying up the property for 60 days. So I think your question is what remedies does a person have after the caution expires after 60 days? So that's why your client should seek a CPL in those 60 days. So your client should start working right away towards obtaining a CPL. Now, if your client doesn't obtain a CPL in 60 days, there's some situations in which another caution can be registered, but there's many situations where the the second caution will not be allowed. So I don't want to get into that. That's kind of another topic. But essentially, many times a second caution will not be allowed. So, I would say in general, you can put on that caution and then right away work towards obtaining a CPL. And the CPL stays there until it's discharged, right? So the owner, the defendant, can bring a motion to discharge the CPL, to ask the court to remove it. So they would do the same thing, look at if there's an interest in land, tribal issue, and look at the Duna factors and present their own evidence and their own arguments to try to remove the CPL. The other way it would be removed is in the broader litigation. So that statement of claim, when it's heard in front of a judge eventually, and the judge decides, okay, let's say the plaintiff loses, then the CPL gets discharged as part of the broader litigation. So the owner can bring a motion, or they can, wait until the broader litigation is resolved. Can a caution be removed before 60 days? My guess is yes. To be honest, I haven't encountered that issue. My guess is yes, but you would have to bring a motion in front of a judge, which would be difficult. But I guess it is possible. I say difficult because the system is pretty backlogged and not very fast. But I think you would need to bring a motion in front of a judge to have a judge order for it to be removed, the caution. I think a more practical aspect is to engage in a conversation with the lawyer who registered the caution and ask them, why is this registered? And try to work it out. Ask them, like, what is the issue and what is your evidence? And then try to convince them that, the caution is improper if you think it's improper. But technically, I think you would have to seek a court order to get it removed before 60 days, which I imagine very few people do because 60 days is quite a short period of time, and you might not be able to see a judge in 60 days. Any other questions? You can put them in the Q&A box. I'll give it another minute. Okay, no other questions. There were just some comments here. Is it possible to get the remaining slides? Yeah, sure. Just email me or I'll post them in the Facebook group. Oh, just a follow-up question here. So the solicitor who registered the caution can remove it before the 60 days? I imagine so. I'd be surprised if they can't. So I imagine they can. If they put it on, they should have the authority to remove it. So I actually haven't encountered that, but I imagine that's the case. If you had the authority to put it on, then you have the authority to take it off. Okay, thank you, everybody. That's the end of the webinar. Thank you very much for attending. Please sign up for the newsletter. As I mentioned, you can email us there. You can also join the Facebook group here to stay in touch. And I hope to see you at the next one. Thank you very much. That's it for today.